I call the honourable member Julianne Gento.
Thank you, Mr. Speaker. I rise to take a short call on the third reading of the Trustee Public Trust Amendment Bill. The Green Party will be supporting this bill. Under current law, as we've heard, a retiring trustee may make an application under Section 46 of the Trustee Act to the courts to have the public trust undertake the trust in their place. And this very old law was originally designed to protect the interests of beneficiaries and the continuity of their family trusts. The reason this legislation is before us today is because of a case in front of the courts in which the trustee of a failed finance company, Perpetual Trust, has declared that it has a conflict of interest and has applied to the court to have the public trust appointed as the trust of last resort. And this would incur some financial liabilities for the public trust for a problem that was not theirs in the first place. And the legislation is very short and simple. It adds a few new tests to help ensure that the public trust does not bear any financial burden of acting as a trustee for a failing investment, for a failed finance company, of which we know there are very, very many. There are already 60, and so we could see more litigation of this type, incurring financial liabilities for the public trust. So the changes in this bill say that the court may only appoint the public trust as a replacement trustee if the resigning trustee has made reasonable endeavours to appoint a replacement trustee, and the resigning trustee indemnifies the public trust for reasonable fees and expenses and provides security for that indemnity. And the Green Party looked at that legislation, the proposed legislation, and thought, although we have concerns about the process, because we only saw this draft legislation on Tuesday evening, and I only saw the regulatory impact statement today, that actually this is quite a reasonable test that should be considered by the courts, and this stopgap measure could prevent potentially the floodgates opening for other failed finance companies to apply to the court to have the public trust take on their trusteeship. So the Green Party is very happy to see the government acting in the interests of a public trust and taxpayers to protect them from financial liabilities caused by failed finance companies. We think that's actually quite a different move, a different direction for this government, who up until now hasn't really proposed legislation that would be protecting the taxpayer, and in fact seems to systematically prefer to protect the interests of monopoly private interests. Like, for example, earlier today we had the Land Transport Management Amendment Bill committee stages, where we've seen changes to the regulations of public transport that will actually entrench the dominance of existing bus operators and will result the transitional measures in that particular legislation. The government has declined to alter those transitional measures in a way that would actually save taxpayers money, save regional council ratepayers money, and result in lower bus operating costs. And presumably they've done this because they're really on the side of the shareholders of the private bus companies, not on the side of the ratepayers and the taxpayers who deserve to get good value for money. Similarly, there are changes in that legislation that will open up the possibility of going to the private sector to finance some very dodgy motorway projects like Transmission Gully, which essentially mean that we get the same project, but we pay an extra $2 billion. So instead of paying $1 billion for a project that's worth about $500 million in benefits, we'll get to pay $3.4 billion. That is, future New Zealand taxpayers will pay $3.4 billion for a project worth $500 million, so that the private overseas banks financing the company have a nice, solid, safe investment over a 25-year period, and they can earn 10 to 12% returns. So it's an unusual step of this government, and I commend the Minister for looking after the public trust and trying to put in place a stopgap measure, even though it won't affect the case that's currently before the courts. If the court does decide to appoint the public trust as the replacement trustee of last resort for Capital and Merchant, there will be costs incurred, and this legislation will do nothing to protect the public trust from this particular case, but we do hope it will protect the public trust in future cases. Thank you very much, Mr. Speaker.
The question is that the motion be agreed to. Those of that opinion will say aye. To the contrary, no. The